The opinions expressed in this show are the views of the host and not necessarily that of WNKZ and WZKN or Geos Communications. The following presentation is brought to you by the host of the program, who is solely responsible for its content. The opinions voiced in this program are for general information and educational purposes only and are not intended to provide specific legal advice or recommendation for any individual. Listening to this program or submitting email questions to pagasleaseattorney.com or pipelineattorney.com does not create an attorney-client relationship between you and the Clark Law Firm or attorney Doug Clark. No attorney-client relationship shall be formed until such time as your matter is accepted in writing and by the execution of a representation agreement by the Clark Law Firm and the client. It is recommended that you consult with an attorney experienced in oil and gas law prior to entering into any legal agreement or contract.
Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We are located at 1563 Main Street in Peckville. I am here with you every Sunday from 8 to 9 a.m., to provide landowners valuable information that you need regarding the natural gas development here in Pennsylvania. If you are looking for landowner information, this is the radio show for you. At the Clark Law Firm, I represent landowners and only landowners, and I have and I continue to represent clients and landowners in Pennsylvania for such items as gas lease negotiations, pipeline and waterline agreements, royalty issues, royalty deduction issues, which we're going to talk a lot about today. That's going to be the focus of today's show, is going to be royalty and royalty deduction issues. Also represent landowners against gas companies and pipeline companies when disputes arise. Maybe there's a unitization issue with respect to your property. Maybe the gas company or property or pipeline company operated outside the terms of your agreement. For example, maybe have a case where a pipeline company cleared an unauthorized area that they weren't allowed to clear under the terms of the pipeline right-of-way agreement. So do those type of disputes. Doing more and more estate planning work for our clients who are transitioning into the royalty phase of their leases. So we got a lot of landowners who now are starting to see the benefit of these royalties and working with them to make sure that they have a succession plan or estate plan in place for them and their particular situation. Also doing surface use agreements, they're called SUAs, doing surface use agreements, doing well pad agreements, damage releases, meter site agreements, compressor station agreements, essentially, any contract or issue related to the natural gas development here in Pennsylvania. And if you need representation in any fashion, you can always contact me directly at 570-307-0702. That's 570-307-0702. And I represent clients. I have clients all across the state. And as you'll hear me say, I actually have represented clients who own land in Pennsylvania and gas rights in Pennsylvania, but are actually located literally across the world. And we just had a conference call recently with one of my clients who's in Micronesia. So just giving you an idea, very rarely does distance ever come into play to be an obstacle. Many clients in Alaska, California, represented a client in London on several matters, consulted with a client in India. So again, all across the state, have clients in the western part and northeast side, and again, clients all over the world, actually. Again, I am Attorney Doug Clark, and you are listening to All Things Marcellus. And want to remind everybody, we're here every Sunday from 8 to 9 a.m., but you can also, if you miss the show, you can't make it on a Sunday, you can go to the websites at pagasleaseattorney.com and pipelineattorney.com. We have the shows archived and available on the websites. And I've been doing All Things Marcellus since August of 2010. We just started on these new stations to give us a broader base clients or broader base landowners and listeners that can come tune into the show, where before we weren't hitting kind of all the areas where we have a lot of clients and where a lot of Marcellus Shale landowners are located. So we also have the show, again, they're available at pagasleaseattorney.com, pipelineattorney.com. You can go there. The shows are archived. So I think we're at about 140 hours or 140 shows that are available on pagasleaseattorney.com. So no matter what you're interested in, there's going to be a show out there available for you. But it's really important. I talked about this some last week. You want to make sure you have current information. So if you're listening to a show from 2010 or 2011, a lot of things have changed since then. So we want to make sure that you're getting good quality, credible information that's relevant for today. So you want to make sure that if you are listening to some older shows, you're listening with the understanding that circumstances always are changing. Another reminder that all of the shows are not meant to be, or any of the shows are not meant to be advice for any specific individual. We want to get good information out there, make you think about things, make sure that you're considering every side of any agreement before you do anything, and to make sure you're getting some background. And no matter what, like I say all the time, whether it's me or someone else, we want to make sure that you're getting assistance, especially with the items that you need assistance with. We don't want you just running out there and signing something, because far too many times, and as I'm sure many listeners know, agreements are being presented, and there's a lot that can be done, not only to increase the compensation, but to protect your property, and for not only today, but for future generations, your children and your children's children. So, finally, before we dive into the royalty issues, we're also available on iTunes. So I think that's kind of neat. I say this all the time. I'm not a singer by any means, but you can find us for free. You can go to the podcast section of iTunes and download the show there as well. Just type in All Things Marcellus, 140 hours roughly, radio shows available. Listen at any time. And I want to just say, I talked about the websites and encourage you to go visit the website. Whether you're just, if you're looking for representation, that's fine. But if you're just looking to learn and some information, go check out pagasleaseattorney.com. Visit the site. If you have topics or questions or anything you want to hear for or on future shows, feel free to email them through the websites. And I look at all those emails, and we'll look to try to cover these topics and these questions to make sure that you're getting the answers that you're looking for. And again, not specific for any individual, but we want to make people think. We want to get people thinking and making sure that you're protecting yourself as much as possible, because all of these agreements, all of these matters are so important to every individual. Talked some last week, that asset, that property is typically the biggest, most important asset for all people. So we want to make sure that you're protecting that asset. Again, I am Attorney Doug Clark. This is All Things Marcellus. And going to now step into the royalty issue. And as most people know, this is what I see as the biggest issue facing Pennsylvania landowners at the present time. Now, I want to do some education here, kind of set some background. I want to remind everybody, I have done hours and hours of radio shows on this subject. And some of this may be repetitive, but there's always going to be something new, and I can assure you there's going to be a lot new here today that we're talking about. But I want to set the stage again, and want to remind you, if you're listening to the show for the first time, because we're just on these new stations now, if this is the first time, go to pagasleaseattorney.com. Check out the other shows on these issues. Go to pagasleaseattorney.com and look at the royalty segment of the website. An entire segment of the website dedicated to these royalty issues. Our class action arbitration case that we filed against Chesapeake, and also the federal case, which I'll call as Demchak versus Chesapeake, which involves other lawyers, plaintiffs' lawyers representing Demchak and this class of individuals against Chesapeake, and one of which we've intervened and sought to stop that proposed settlement on behalf of our clients. And we have a lot of those filings available there, so you can go and check it out. Great resource. And with everything, as you'll hear me say often, this is me speaking. Go out there, do your own investigation as you see fit. You don't have to take my word. A lot of this information, most of this information is available publicly. Go look at it. Look at the Demchak versus Chesapeake filings. Look at our AAA filings and our arguments. Visit the websites. Those are filed documents. Get this information and make the right decisions for you. It's a theme that I say often. I want landowners to be educated and informed and to make the right decision for themselves. That is the key. That's what everybody should want. Any attorney should want that. The gas companies may not want that because they may not want you to be informed. But we need to make sure that you're informed, and then you decide, hey, is this something that I want to be involved in or challenge? Or is this something that I just rather sit on the sidelines? But we want to make sure if you're going to sit in the sidelines that you're aware of why you're sitting on the sidelines, and you're aware of what's being played out on the field that you're not involved in. So really want to make sure that you're informed. So, okay, turning to the royalty deduction issue. Basic stuff here. What are deductions? What are we talking about? Well, gas is produced, it comes from below the surface of the ground, comes up to the surface of the ground at the wellhead. At the wellhead, then the gas is transported, and they call it's gathered with other wells, and then it's transported. It may be compressed to increase the pressure of the gas. It may be dehydrated to get some water out of the gas. There could be other processes that occur, but those occur, obviously, in our example here, after the gas exits the surface of the ground and gets to the wellhead. So once the gas is at the wellhead, it's going to be physically moved and potentially undergo some processing in order to get it further downstream. So the example I'll use today, and I use all the time, is that if gas is produced and it comes out of the ground at the wellhead, it then goes downstream through a series of pipelines. Ultimately, it will hit an interstate gas pipeline, or a pipeline that's going to go from one state to another state, in what's often called a transmission line. So you'll hear me use those terms interchangeably on occasion. So gas goes from the wellhead. It's transported from the wellhead through gathering process, transportation process. It may be compressed, may be dehydrated, and some other processing, and it gets to the point of the interstate or transmission pipeline. Now, in most cases, we see gas being sold at the interstate pipeline. In most cases. So what does that mean? I often use the example, and it's just an example, of gas being sold at a $4 per unit price. And we'll say this is MCF, but we'll keep it easy, and we'll say it's sold at $4 per unit at that interstate or transmission pipeline. So though it's sold there at $4, there are costs that are incurred. So you incur costs to get it from the wellhead to that interstate pipeline. And what type of costs? Well, like I said, we're talking about gathering costs of pipeline transportation, transporting the gas. We're talking about potentially compression and dehydration, as well as some other processing that may occur. So if gas is sold, in my example, at the interstate or transmission pipeline at $4, let's say in an example that the cost from the wellhead to the interstate pipeline that a company incurs is $1 in total. So that's the total post-production cost. What does that mean? So we'll make up numbers to illustrate this. Say that the company has to pay 75 cents per unit of gas to transport the gas. So they have to pay a pipeline company 75 cents per unit of gas to get that gas from the wellhead to the transmission or interstate pipeline. So that is a post-production cost of transportation, 75 cents per unit in my example. Keeping it simple, let's say they also have to pay a pipeline company a gathering fee. And we'll say that that gathering fee in this case is 15 cents per unit. So again, we have a total now of 75 cents per unit to transport it through transportation pipelines, 15 cents per unit to transport it through gathering lines, and we'll say it's another 10 cents per unit for compression. So when we add these numbers together, so if it's 10 cents per unit for compression fees, add that to 15 cents per unit for gathering fees, that gives us a quarter, 25 cents. Then we have the company has another post-production cost of transportation, which we're going to say is 75 cents. The total then is $1 in post-production cost. Those are the cost, again, from the well to the point of sale, in my example, the interstate or transmission pipeline. So if it is sold at $4, there is $1 in cost combining the gathering, transportation, and compression fees. There's $1 in cost, and the question is, can the company deduct that $1 in cost? So instead of calculating your royalties at gas at $4 per unit, they would calculate royalties at gas at $3 per unit. So you have the sell price in our example, $4, and the word deduction comes in of deducting those post-production costs of gathering, transportation, and compression in our example to give the landowner a lower royalty payment, or a net payment here of a $3 unit price. So obviously, as a landowner, you would want to have the royalties paid at $4 versus $3, clearly. Okay, we're up against this break. I'm going to explain a lot more, but hopefully we got a nice little basis here. You are listening to me, Attorney Doug Clark from the Clark Law Firm, and this is All Things Marcellus. We'll be right back after this break. I'm Attorney Doug Clark of the Clark Law Firm. I represent landowners and only landowners. Join me each Sunday for All Things Marcellus from 8 to 9 a.m. on KZFM. Since August 2010, I have hosted All Things Marcellus, a weekly radio show for you, the landowner. Whether you are interested in royalty issues and deductions, leasing issues, pipelines, estate planning, or any other issue related to natural gas development, All Things Marcellus is the radio show for you. Tune in every Sunday from 8 to 9 a.m. on KZFM. And call me, Attorney Doug Clark, at 570-307-0702. That's 570-307-0702. And make sure to visit our websites at pagasleaseattorney.com and pipelineattorney.com for outstanding landowner information. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're talking about royalty deductions and post-production costs and what they mean to landowners, and then I'm going to get into our class action case, the proposed settlement that's out there in the Demchak versus Chesapeake case, and kind of outline that some. As I said before, I have done multiple radio shows on this subject. I come in each week, and I say, okay, I have all these different materials or subjects that I want to get to. Well, rarely and probably almost never do I get to them all. So I came in today. I knew I might have been a bit ambitious, but I came in. I have all these numbers and royalty information to get to, and I could tell already after the first segment I'm not going to get there. Excuse me. But importantly, I really want to get this background set, because if you don't have that foundation, then as we advance to some of these slightly more complicated areas, it's going to be more problematic. And as we are on new radio stations now and we have new listeners, I know a lot of people may not have heard me talk about these issues before. So we want to kind of step back, and if you have heard these things before, it's still very, very important, because I assure you there's got to be some things that you've missed along the line, because these are complicated issues, and we want to try to make them as simple and as easy to understand as possible. And let me say this too. These issues apply to everybody, whether you're leased to Chesapeake, whether you're not leased to Chesapeake, whether you have a negotiated gas lease that has special royalty addendum terms, or whether you just signed a form gas lease that the company provided back in 2005, 6, 7, and even earlier. These issues all still apply to you. As a Pennsylvania land or gas rights owner, you need to understand these issues. You need to. Now, what you decide to do with this information and understanding once you have it, that's up to you. But you really owe it to yourself and your family and your children to understand these issues, because we want to make sure that you're not being taken advantage of, and even if there's nothing you can do, you want to be able to understand why is this the situation, what are these deductions, and what is this that everybody's talking about here. So very, very important. I am Attorney Doug Clark. This is All Things Marcellus. And getting back to this, so that first segment, we finished up with going through post-production costs, explaining what those terms are. And you hear this buzzword all the time, deductions. I'm getting too many deductions. My deductions are too high. I don't want to have deductions. I'm about to enter into a gas lease. I want royalties without deductions. What are we talking about? Well, deductions are these post-production costs such as gathering, transportation, compression, dehydration. Those are examples. Now, there are some others, but those are examples that we see most often. So I'm going to focus on those ones because they're the most common post-production cost. So what we have is we have gas coming out of the ground at the wellhead. Gas typically isn't sold at the wellhead. It is transported through a pipeline system and may undergo processing such as compression, dehydration, and some others as well. And it ultimately reaches the interstate pipeline or the transmission line. Very often gas is sold at that point. So post-production cost for our discussion is costs that are incurred from the wellhead until that gas reaches the transmission or interstate pipeline, and that could be the Tennessee gas line, the Transco gas line, the Millennium gas line up in New York. Those are examples of transmission or interstate pipelines. Okay, so we have post-production costs, and what happens is when we talk about deductions, those are the subtraction of your royalty or from your royalty check or your royalty balance, what you're going to receive. What we have is subtracting those post-production costs from the overall royalty. And I use this example. Say gas is sold at the interstate transmission line, and we'll say the Tennessee gas line in our example. If it's sold there at $4 per unit, and there was $1 incurred in getting that gas and compressing it and dehydrating it, whatever those costs may be, if there's $1 incurred from the wellhead to the interstate transmission pipeline to Tennessee in our example, those costs can be deducted if your lease allows that. So deductions are the subtracting. In my example, we went through and said there was $1 of post-production costs. So if it was sold at $4, if you had a royalty and had no deductions, or had a lease and there was no deductions being taken, your royalty, say it was 15% royalty, would be calculated at gas at $4 per unit. But if you had an older lease that clearly allowed post-production costs to be deducted, then instead of getting $4 royalty rate or instead of having your royalty calculated at $4 per unit, you would have your royalty at $3 gas because the post-production cost of $1 in total would be deducted, and so your royalty at 15% would be at $3 gas as opposed to $4. Obviously, as a landowner, you want that higher price. So, where does that leave us? Well, we now understand, hopefully, what these post-production costs are and what it means to have these costs deducted. Well, there are two really, really big issues that I see out there. And one issue faces all landowners, and another issue faces a certain group or class of landowners. And we'll start by saying the biggest issue or the broader issue, and that being one that would affect everybody. If you have, well, I shouldn't say everybody, because if you're not having deductions, it wouldn't affect you, but it would affect everybody who has deductions being taken. So if you have an older lease that doesn't have any addendum, or even if you have a lease that has addendum and you're receiving deductions, one common question is, well, are these deductions appropriate? Are they allowed? And we'll get to that because that's the second big issue. But the other issue is, are the deductions that are being taken, are they excessive? Are they appropriate deductions, or is the company taking too much money from me in post-production costs? And that's where we get into some landowners, and we're seeing that, especially, and we'll talk a lot about Chesapeake because we see them clearly as the biggest offender here, where the deductions or the expenses for gathering and transportation are enormous relative to what we see from other companies. And I look at a lot of royalty checks all the time and literally every day. And so we're looking at these and we see that in Chesapeake's case, there tends to be, and especially in some areas, very high percentage of the royalties are being taken in these deduction charges for post-production costs like gathering and transportation. So what we see at times is that these deductions for some people can range up to, say, 80% and sometimes even higher. And there's a lot of articles and information out there where you're seeing higher, but I personally have seen around 80% in several occasions. Now, it's not always that high. Different areas have different levels of deductions. But to give an idea, as an example, hypothetical here, if you had a lease and it was sold, or you see when you get your royalty check that the gas was sold, if I got this interstate pipeline price, that Tennessee price, you see that the gross price of this gas was, say, my royalty would be $10,000. But after these deductions, and say for gathering and transportation, that the landowner ends up only getting $2,000, that $8,000 is taken or deducted from the landowner's royalty check for post-production cost. Then the question becomes, wait a second, how is that appropriate? I went through and I encourage everybody to read the ProPublica article. You need to read this article. I did a whole show, or most of a show, going through it. Go to the websites, check it out. If you need a copy, you can contact me through the websites and we'll email you a copy of this article. Very, very interesting article. But everybody has to. If you're leased to Chesapeake, you have to read this article. So it doesn't seem appropriate. Many landowners obviously are very upset that why am I having 80% of my royalties taken in deductions for these post-production costs? And that ProPublica goes into some reasons why. And I'm not going to, again, discuss that now, but we will, I assure you, be talking a lot about this going forward. But go to pagasleaseattorney.com, check out some of these other shows. You owe it to yourself to do that. It's a long article, but I've not talked to anyone who's read the article who's not said, wow, I'm really glad I read that article. I am Attorney Doug Clark. You're listening to All Things Marcellus. And let me kind of reset here. So we say the big issue, one of the biggest issues, or one big issue facing Pennsylvania landowners is whether you have special royalty language or not, and you have deductions being taken, are those deductions excessive? And we certainly know that the number one company that's complained about with these deductions has been Chesapeake, and I certainly would say rightfully so, in my opinion, in my experience, and again, my opinion. Now, not all the time do we see Chesapeake taking 80% in deductions. Thank heavens. So deduction numbers and these levels can change and do change all the time. There's a lot of variables involved. But one big question for everyone is, and whether it's Chesapeake or any other gas-producing company, is the company taking too much from my royalties in deductions? And so that's one issue. Now, as a part of that issue is also, aside from just are they taking too much, is where should gas be calculated? Where should the value of this gas be calculated? Should I be getting the gas price at my example of $3, or should the gas company not be allowed to reduce my royalty check by these costs? And a big issue and a movement is going on through the Assembly, and you'll hear this House bill where there's discussions as far as we have what's called a Guaranteed Minimum Royalty Act. The Guaranteed Minimum Royalty Act in Pennsylvania says that all landowners are to get 1/8 in royalty as a bare minimum. They cannot get, the gas company can't pay them below 1/8 or 12.5% royalty. That's the guaranteed minimum. Now, you are free to negotiate higher than that, but under Pennsylvania law, landowners are guaranteed 12.5% royalty. Now, a question understandably comes up and says, well, wait a second. If, in that earlier example, the gross royalty was $10,000 and I'm only getting $2,000, am I truly getting 12.5% royalty or not? So here's what we're talking about there. Let me simplify this some. What we're talking about there's a Pennsylvania Supreme Court case called Kilmer versus Alexco. And I've done, again, another show on that, and I think it was from December of last year. Encourage you, we'll be talking about it more, but the biggest royalty case in Pennsylvania. In the show of December of last year, available on pagasleaseattorney.com, really break down Kilmer in a lot of different ways. Very, very good show. I have to say, I really encourage you to go check that show out if you're interested in these issues. I think it's a must listen. And read Kilmer. Go and research it, Google it. You can find it. It's online. Read the Kilmer versus Alexco decision. If you can't find it, email me. I'll get it to you. So what we have there then is the Pennsylvania Supreme Court said, yes, you were allowed to take deductions. A gas company is allowed to do this thing they call the net back method of calculating royalties. So in my example, if gas was sold at $4, you could net back the price of the gas back to the wellhead. In my example then, so you take that $4 and you deduct gathering, transportation, compression, and any other post-production costs that you can deduct those in this process called a net back method, and give the landowner the guaranteed minimum royalty of 12.5% at the wellhead. That you weren't guaranteed as a landowner 12.5% of the sell price, saying $4, but you were guaranteed 12.5% of the wellhead price. And there's a question of, is that the proper royalty calculation method? And the idea of the House bill and the legislation that the many parties are looking to move forward, and certainly landowners, is should we be guaranteed that 12.5% we were provided by the state in the Guaranteed Minimum Royalty Act? Should that royalty of 12.5% be on the sell price of the gas at the interstate transmission line, or only at the wellhead price? And that's a substantial difference, substantial in many, many cases. And think about it, because what we're talking about is eliminating some of these very costly deductions for transportation and gathering, especially when we look at some of these areas with Chesapeake, but it's impacting in all places. That's a substantial amount of money from that wellhead price to the transmission line or the interstate gas line price. So that's what that movement is there, and that's affecting anybody who's subject to looking at this Guaranteed Minimum Royalty Act. Where are my royalties going to be calculated? Big, broad issue affecting many people. We're up against the second break. I went a little over here. I am Attorney Doug Clark. This is All Things Marcellus. We're going to get back, and we're going to talk about market enhancement clause and royalty deductions under a whole different set of leases. Very, very important. We'll be right back after this break. I'm Attorney Doug Clark of the Clark Law Firm. I represent landowners and only landowners. Join me each Sunday for All Things Marcellus from 8 to 9 a.m. on KZFM. Since August 2010, I have hosted All Things Marcellus, a weekly radio show for you, the landowner. Whether you are interested in royalty issues and deductions, leasing issues, pipelines, estate planning, or any other issue related to natural gas development, All Things Marcellus is the radio show for you. Tune in every Sunday from 8 to 9 a.m. on KZFM. And call me, Attorney Doug Clark, at 570-307-0702. That's 570-307-0702. And make sure to visit our websites at pagasleaseattorney.com and pipelineattorney.com for outstanding landowner information. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I want to say we're talking about royalty deductions today and giving a real basic kind of course and explanation of royalty deductions, post-production costs, making sure everybody's kind of up to speed. It's just starting on these new stations, so want to make sure we give them a little bit of a kind of a primer, and we're going to keep on going with this. I can tell already I'm not going to get to anywhere near as much as I'd hoped to in some of these royalty numbers, because I'm going to talk a lot in the upcoming weeks about the proposed Demchak versus Chesapeake settlement, what we're doing, how these numbers play out, and how they play out with clients of ours. I want to take this opportunity to let everybody know that we're going to keep talking about this, but I want to make sure everyone understands that if you are receiving royalties and you want to have a free, confidential, no obligation evaluation, where do you fit in this process? And I'm going to talk more and explain more, but I just want to take this opportunity to say I do free, confidential, no obligation. I want to stress that. There's no obligation of any kind in any way. And what I do is if you have a lease but are not getting royalties yet, if you want to send me that lease, I will let you know whether I believe that you fall into the class that's involved in the Demchak versus Chesapeake proposed federal class action settlement. If you fall into the class of the individuals that we're working on and what we represent in the Burkett versus Chesapeake arbitration case, and again, it's essentially the same class, let you know kind of where you fit in and what's going on. What you want to do or what you do from there is entirely up to you. You can do nothing, but at least you understand, because a lot of people don't understand that they're in they're in the class, but they don't understand that, and they don't know why. And that's a really important thing, that you understand today where you fit in this process. Now, if you are actually getting royalties, you can send me a month of royalty statements and your lease. I stress, confidential, won't be disclosing any information, and let you know, in my opinion, whether I feel the gas company or companies are inappropriately taking deductions for post-production costs from your royalty checks. Now, I can't tell you by looking at the check whether a company is overcharging you deductions. I'm not going to be able to tell you that. But what I can tell you is I'm going to look at your lease language for you. I'm going to look at the addendum language regarding royalty calculation. Look at that language, look at your royalty check, get back to you with my written opinion, saying, hey, look, I think that in your particular case, the gas company or gas companies are inappropriately taking deductions, and here's the reason why. Or I may unfortunately write back to you and say, well, unfortunately in your case, I believe that the company is authorized to take deductions that they're taking based upon, and it's typically because of the Kilmer decision I referenced earlier. But it'll give you that evaluation. Now, if I write back to you and say, hey, I think the company is taking unauthorized deductions, here's the reason why, you don't have to do anything about it. I want to stress that. This isn't a gimmicky thing. We want to know, we want you to know where you're at. We want to know how this applies to you, and whether you do something with that information is up to you. We represent now over 150 individuals, and almost we're close to about 5,000 acres of clients, and combined our clients own, who fall into this category, who we feel have unauthorized deductions being taken. So we're working day in and day out on these files and fighting, in particular Chesapeake, saying, hey, company, you're not allowed to do what you're doing. So if you want to find out, hey, is this applied to you? Where are you at in this process? We want you to know that. And again, it is without obligation and it's confidential, no strings attached. And how you want to handle it from there is up to you. But I really do. I want everybody to be informed. This is an extremely important issue, one, as I see, as a $1 billion plus issue affecting Pennsylvania landowners. Thousands of people, thousands of leases, I feel are being calculated, the royalties are being calculated improperly, and landowners are having deductions taken which we don't feel are authorized. And these numbers are staggering. And you need to find out, are you in this class? And what can you do about it? And do you want to do anything about it? You need to get this information. That information is free. Free information is great. It's good, credible, reliable. That's what you want, and you make the decision that's right for you. So if you're interested in that, another thing I'll say, many people don't understand that this proposed settlement applies to them, even though they're not getting royalties. So if you're leased in whole or in part to Chesapeake, and you have this, we're going to talk about the market enhancement clause or similar language, this proposed settlement is going to apply to you as it's proposed, even if you're not getting royalty checks yet. A lot of people don't understand that. You need to know that. So again, send me your lease if you want. I'll look at it. I'll look at the royalty checks and give you my opinion. You can do that. You can contact the office anytime at 570-307-0702. I promise you, you're not going to be harassed. We're not going to bother you. We're not going to keep calling you. I want you to know, where do you fit into this? What are your options? You need to be informed. Nobody should be afraid of the landowners being informed. Companies, lawyers, nobody. We want you to be informed and make the decision that's right for you. And if you ultimately say, hey, look, I like this settlement, I want to be a part of it, that's great. You've made an informed, intelligent decision. But please don't sit out there and be afraid to get information, especially when this information is available and it's free. And you can contact me again anytime, and I'll do this review for you. I won't bother you. We want to get you informed. So it's 570-307-0702. Contact me anytime. Make arrangements to get me the information. 570-307-0702. Again, check out the websites. Learn more about this as well through the websites at pagasleaseattorney.com and pipelineattorney.com. I am Attorney Doug Clark. This is All Things Marcellus. I want to get back to it. So want to talk about now. Okay. What's he talking about, this class action? What's he talking about unauthorized royalty deductions? Stepping to the second kind of major part of this issue, and one which we're very involved in, is landowners around 2008, but I stress that I have clients, I think as early as 2006, that have a provision added to their lease by way of an addendum term. And it can be headed or have a heading that says market enhancement clause, market enhancement provision, may say market enhancement, may say just simply royalty, or may not have any heading at all above it. So what's important is, well, what is this language? Well, what happened is, especially around 2008, we started to see landowners as leverage and negotiation power increased on behalf of the landowner's side of things, and there was competition. We started to see a term come up, very common, called the market enhancement clause. And what that is that's a provision that provides for an alternative way of calculating royalties. I talked earlier about the netback method in our example of gas being sold at $4, but then deductions being taken and the landowner receiving royalty payments at gas at $3 per unit. Well, again, what happened was, as negotiation continued and as leverage continued, we started to see landowners being offered what's additional addendum terms that addressed royalty calculation provisions or royalty calculation. And very often the most common form is called the market enhancement clause. I can't stress enough, you got to be really careful because there's a lot of ways that this thing can be written, but it's often referred to as the market enhancement clause. I stress, it doesn't have to say market enhancement. There's many offshoots of this. So even the proposed settlement deals with the market enhancement clause or similar language. So let me tell you, what is the market enhancement clause? So if you have your lease out, look at it. If you don't, hey, look, you can always go PA Gas Lease Attorney, go back, replay the show, see if you have it. Send your lease to me, and I'll let you know if you have it and how this applies to you. But here's an example of the market enhancement clause. Here's the terms. It says, market enhancement clause. It is agreed between lessor and lessee, so that's landowner and company, that notwithstanding anything herein to the contrary, it's kind of legalese for saying despite anything else, all oil, gas, or other proceeds accruing to the lessor, who's the landowner, under this lease or by state law, shall be without deduction. Sounds great so far, right? All royalties shall be without deductions, proceeds without deductions. Goes on to state, directly or indirectly, for the cost of producing, gathering, storing, separating, treating, dehydrating, compression, processing, transporting, and marketing the oil, gas, and other products. Let me pause there for a second. Wow, that's great. We're saying that there should be no deductions here for all of these different items we just went through. So shall be without deduction for producing, gathering, storing, separating, treating, dehydrating, compression, processing, transporting, and marketing the oil and gas and other products produced hereunder to transform the product into marketable form. Very, very important. So no deductions, goes through the list, gathering, treating, dehydrating, compressing, transporting. No deductions to transform the product into marketable form. That's where we get this marketplace. Okay, next, quoting again from this sample language. However, we always want to look at however. However, any such costs which result in enhancing the value. So any such costs that result in enhancing the value of the marketable oil, gas, or other products to receive a better price may be deducted from the lessor or landowner's share of production, so long as they are based on the company's actual cost of such enhancements. I know there's a mouthful and a couple mouthfuls there, so let me go back and highlight this and kind of paraphrase it. So what this market enhancement clause is saying, and that's part of the clause, what it's saying is that despite anything else in the lease, so this is the addendum term, and it trumps or prevails over the lease in virtually all cases. So despite what the language is in the lease, despite that, there shall be no deduction. And it lists gathering, transporting, marketing, processing, goes through all of those. Says no deductions. None of those can be deducted to transform the gas into marketable form. Then it states, though, however, any of these costs which result in enhancing marketable gas can be deducted. So in our case, and we'll focus on Chesapeake, what we're talking about is Chesapeake says, well, gas is actually marketable at the wellhead. It's marketable there. It is in a marketable form at the wellhead. So by us transporting it, gathering it, compressing it, dehydrating, what we do after that wellhead, that gas is marketable form at the wellhead, so therefore when we transport it, we gather it, we compress it, what we're doing is enhancing the value of marketable gas, and because these are quote-unquote enhancements, they are not deductions. So we can subtract or deduct the enhancements from the price. Back to my example. If gas is sold at $4, what Chesapeake would say under this market enhancement clause is, in my example, so this interpretation of market enhancement clause under my example would be like this. Well, gas may have been sold at a transmission line at $4, but if you apply this reasoning, well, it was to get it there cost $1, but when it started at the wellhead, in this example, at the wellhead, Chesapeake would say this gas is marketable at the wellhead. And that transportation, that dollar in cost that we talked about from the beginning, gave the example of 75 cents to transport it, 15 cents to gather it, 10 cents to compress it, in my example, for $1 of post-production cost. Well, this interpretation, Chesapeake's interpretation in that example would be, no, those are enhancement costs, not deductions from the sell price of $4. Those are enhancing the value of $3 gas. So therefore, we can subtract those costs because they are enhancements. Now, I talked about the market enhancement clause. This same reasoning, I said, this is why it's so important. You can look at your lease, so I don't have that language. Well, you may have very similar language. You may have language that says what I call the ready for sale or use clause, which says, in this example, I'll read this quick, we're up against it here, but royalties shall be paid without deductions for the cost of producing, gathering, storing, separating, treating, dehydrating, compressing, transporting, or otherwise making the oil or gas produced from the leased premises ready for sale or use. So it says no deductions in order to make the gas ready for sale or use. Well, Chesapeake would say gas is ready for sale or use at the wellhead. So therefore, any costs that we incur after that are actually enhancements that we can then deduct. So we can pay you the $3 price in my example because that is gas that is ready for sale or use at the wellhead, and any cost after that to get it to the point of sale in my example of $4, those are enhancements, and we can therefore subtract those. What's crazy, well, there's a lot of things that's crazy, but we're going to talk about this when I get back, but many other companies under the same lease form do not treat the gas or treat this provision or interpret this provision in the same fashion because they give the landowner that $4 price, not the $3 price. We're going to talk about that. You're listening to All Things Marcellus with me, Attorney Doug Clark, and we'll be right back after this break. I'm Attorney Doug Clark of the Clark Law Firm. I represent landowners and only landowners. Join me each Sunday for All Things Marcellus from 8 to 9 a.m. on KZFM. Since August 2010, I have hosted All Things Marcellus, a weekly radio show for you, the landowner. Whether you are interested in royalty issues and deductions, leasing issues, pipelines, estate planning, or any other issue related to natural gas development, All Things Marcellus is the radio show for you. Tune in every Sunday from 8 to 9 a.m. on KZFM. And call me, Attorney Doug Clark, at 570-307-0702. That's 570-307-0702. And make sure to visit our websites at pagasleaseattorney.com and pipelineattorney.com for outstanding landowner information. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And want to say again, now I'm on the news stations. I actually have a little more flexibility on my time, the way I'm doing things. I guess I have a little more control. So I tend to run over a little bit. So we're up against, we're going to have a shorter segment here. And hopefully now some things make a little more sense. And we're talking about the importance to understand what you have in your lease. And again, that evaluation. If you are looking for an evaluation, want me to give you my opinion, confidential, no obligation, you can contact me at 570-307-0702. Very important that you understand where you stand in this process and what choice you have and whether you feel that deductions are being taken from your royalty check, which are in violation of the terms of your oil and gas lease. Here's a very important thing. Chesapeake in Pennsylvania partners with a company called Statoil. And in every Chesapeake lease that I'm aware of, Statoil is a partner with Chesapeake. Now, sometimes Chesapeake has other partners like Anadarko and Mitsui and Statoil. But from what I've seen, I believe in every lease in Pennsylvania that I've seen, Statoil is now a current partner with Chesapeake. So we talked about Chesapeake takes the market enhancement clause and they take the ready for seller use provision, and they say that under these terms, they're allowed to take these deductions for post-production costs. What's very, very interesting is Statoil and also Mitsui. But Statoil, who's a partner with Chesapeake in all of these leases, and the leases that have the market enhancement clause, the ready for seller use clause, all of these leases that have this language, Statoil doesn't take any deductions for post-production costs. Neither does Mitsui under the same lease. Not under two different leases, literally under the same exact lease. So if that lease was a 5-page lease that you signed, these companies share ownership in a portion of that lease. So it is the same language, not the same language in two different leases, literally the same lease document, the same addendum. So when you receive your royalty checks from Statoil and Mitsui, you do not have any deductions taken for post-production costs if you have the market enhancement clause, ready for seller use clause, or similar language. And landowners that are receiving checks know this. If you are having deductions, you got to get that fixed because you shouldn't be. And the companies agree that they're not going to take those deductions. So make sure you're not getting deductions if you have this language and you're leased and you're receiving royalties from Mitsui or Statoil. However, under that same lease, Chesapeake is taking deductions. So we have the same language being interpreted very, very differently between different companies. And then to play that out further, I just gave you examples of companies treating this differently under the same exact lease. But Cabot, Southwestern, Shell, Talisman, WPX, and others are not taking any deductions from landowners, not subtracting post-production costs from landowners who have the market enhancement clause, ready for seller use clause, or that similar language. No deductions. So we talk about this proposed settlement. We're going to really dive into numbers next week. Really get into numbers next week. So as important as this show is as a primer to get you educated and up to speed, next week we're going to take it a step deeper, and it's going to be something that we're going to place or put to you in a way that you're going to be able to understand, but very important issues. So other companies aren't taking deductions with this same language. So now a question is, and just touching on this settlement, if this proposed settlement, which we are objecting to and contesting and fighting against, if this proposed settlement were accepted, just briefly touching on one aspect of it, the company moving forward, Chesapeake in this case, would be able to deduct, instead of taking 100% of these costs of the post-production costs, instead of deducting 100%, they would be able to start deducting after September 1st of 2013. Instead of deducting 100%, they are now able to deduct, if this were approved, 72.5%. 72.5%. So the landowner would get 27.5% of these post-production costs that are being deducted. Well, one of the major concerns that I have, and I'm really going to dive into this next week, is, first off, we don't believe that's enough. Second, then, what are companies like Statoil, who's paying royalties under the same lease, are they going to continue to pay the landowner 100% of these costs? They're not going to deduct any of them when their partner under the lease is deducting 72.5%, which is a very substantial amount. What's Statoil going to do? What's Mitsui going to do under the same lease? Then, landowners out there lease to Cabot. Landowners out there lease to WPX, Talisman, Southwestern. Are they going to continue with leases with the exact same identical market enhancement clause language? Same language, different lease, but same exact language. Are they going to continue to give the landowner 100% of this money and not deduct anything when Chesapeake has, playing this thing out, if it were approved, Chesapeake's only paying landowners Chesapeake is paying landowners 27.5% and deducting 72.5% of these post-production costs. What is going to be the ripple effect if this were approved? So you're sitting out there and you're saying, boy, thank heavens I'm not leased to Chesapeake because I don't believe what they're doing is proper. Well, be careful because, where does this go from here if this were approved? So I'll finish with this again. I promise you we're going in deeper and, go back, listen to this. Go back to pagasleaseattorney.com. Listen to some other shows. We're going even deeper next week. We're going to talk more about the settlement, more about the realistic impact on people. And you want to find out what the heck is going on, I'll give you that free evaluation anytime. Just contact the office, 570-307-0702, 570-307-0702. Contact us through the website at pagasleaseattorney.com. There is no gimmick here. There's no obligation. It's confidential. I'll write back to you and tell you whether you fall into this class. Does this proposed settlement apply to you? Where are you in this? And you can make your decision whether to do anything or do nothing at all. You're listening to All Things Marcellus with me, Attorney Doug Clark. Have a great week, everyone.